Hi, I'm here today to talk with you about academic freedom and our rights as teachers or professors. Article 19 says that the University Declaration of Human Rights gives the definition of intellectual freedom. And intellectual freedom is, and I quote, everyone has the right to freedom of opinion and expression. This right includes freedom to hold opinions without interference and to seek, receive, and import information and ideas through any media regardless of frontiers, unquote. Now, this means that you have the freedom to think, study any ideas, put forth any ideas that you want, and go anywhere and join a political party of your choice, go to a rally of your choice, freedom of speech, freedom of music, whatever you want. But then you go to the classroom and you have academic freedom, and that is limited to students and professors, and that limits your intellectual freedom in the classroom. And academic freedom is, the Free Law Dictionary says, and I quote, academic freedom is the right to teach as one sees fit, but not necessarily the right to teach evil, unquote. Now that means that that you can teach any research anything that pertains to the subject you are studying. Um, but you want to avoid too controversial of a subject. And you don't want to teach anything that's unlawful. Um, but other than that, it's pretty well, protected by the First Amendment. Now, I want to talk about an organization that has been around for over 100 years, and you can become a member today as a university professor or as a graduate student. That is the AAUP, the American Association of University Professors. They have been around since 1915, and they help out with investigations, and they have helped out with court cases, and they help protect academic freedom. They're 1940. They came out with the principle of academic freedom and tenure of teachers. And what they do is they make sure that you get the due process of law, and that nothing goes against the your First Amendment, freedom of speech, or the 14th Amendment. And they make sure that everything that is done to you is constitutional. If they lay you off or fire you, they make sure that it's done according to the constitutional rights, and that if you have tenure, that they hold to the tenure. You're not supposed to be fired unless it's financial or totally some kind of an immoral act. Um, let's look at some cases that the AAUP was involved in. We have Sweezy versus New Hampshire, 1951, 57, and he was he had previously taught at Professor Sweezy previously taught at Harvard, started the Harvard Teachers Union. However, he went to New Hampshire and was teaching there, but he was always involved in the Progressive Political Party. He had helped Wallace campaign, and he gave lectures on Marxism, and that's okay because you teach the different political parties. You got to give examples. But in 1951, New Hampshire had got a law and said that anybody that is involved in subversion is not supposed to have a state office. And in 1953, they gave the state attorney the ability, the legislator, to investigate people. Well, the state attorney thought that Professor Sweezy was doing things that were a little bit suspicious of subversion. So he brought him in to question him. And the questions he asked him were kind of personal, like his wife involved in the Progressive Party? Was she involved with somebody that was involved with the Communistic Party? And he wouldn't answer these questions. He could have taken the Fifth Amendment, but he didn't want to. So the state attorney went to the court and got a contempt of court and put him in jail. Well, the AAUP got involved, and they appealed it to the Supreme Court of the United States. The Supreme Court of the United States got involved, and The definition of subversion is that anything that goes against the constitutional government, and to overthrow it with a violent act, or get involved with people that want to overthrow the government through violent acts. And they said that they didn't properly identify that. They did not properly go through the due process of law. They didn't have any procedures that they followed to put him in jail, or even to, convict him of that crime. That he did. They went against his academic freedom according to the First Amendment, so they reversed the um, the judgment. Okay, now looking at Urovsky versus Gilmore. Now, this was the Commonwealth of Virginia had a state law that any of the computers that were leased by the state were not to have any sexually explicit material on them. Well, some of the students sued the state because they said, one student said that in order to express her poetry, she had to have nudity, teach nudity, and have it for her research. Another student said for her sexual health in queer studies, women's studies, and men's sexual studies, she needed to research sexual material. And a law officer that was teaching class, he needed to have these sexual explicit photos on there to identify the different sexual crimes for his officers that he was teaching. And so they won the case. However, the state of Virginia took it to a higher course in the 4th District, and the majority of the judges said that their First Amendment was not affected by the law, that there is to be no sexually explicit material on the state run computers. And so they put that law back into effect, and they reversed the other law that was in effect. And so they were not allowed to have the sexually explicit material. Now, today, like I said, the AAUP does investigations. One investigation that they are involved in today is Professor Schmidt and the Nunez Community College in Louisiana. What it was Professor Schmidt was over 22 years. He was a teacher at Nunez College, and he in I think in the 1990s, he became an associate English professor, and he also had a job in the general studies as he critiqued the students for the wrote up reports for the accreditation uh, committee of the for the school. And they got a new accreditation appointee, and her name was Dr. Lutz, and she said that he needed to put some material in, and it was fabricated, so he didn't want to do that. And they went in his office and took the material away, and they actually sent in his name on the fabricated material, and he said he didn't want his name on it, and he wrote emails, and they sent his name in anyway, and he wrote emails saying that he did not he wanted his name taken off. And they had a phone conference and said, your contract will not be renewed because you are no longer a fit for this university. For this college. And so he got the AAUP involved, and they wrote and they said he is a de facto a tenure teacher. You do not do a review with the dean, the chancellors, and the accreditation officer, and come up with a reason of why you are laying him off, and he has tenure. And so they sent that in, and they said you went against his academic freedoms and due process of law. Thank you, and have a good day.